So good morning, everyone. A warm welcome to all of you for today's event, which is on Prevention of Money Laundering Act. And this event has been hosted jointly by Venture Code Legal and Indian Lawyers Association Ludhiana chapter. Thank you so much for joining us on a Sunday morning. And myself, Madhura. Let me introduce Indian Lawyers Association very briefly to all of you. So ILA is a national level organization working to get together all the legal professionals across the country on one platform. So we do this essentially to promote continued legal education or to create a common voice of all the lawyers. And we host different webinars, seminars, events, and social events, cultural programs. We offer mentoring and guidance to young lawyers and law students across the country. The main motto is also to promote pro bono and public service activities by the legal profession. So our main way of operations is through having local chapters. So that brings in local flavor across the operations of that chapter. And all these chapters are free to orchestrate their chapter activities the way they wish. So we have about 75 chapters currently. If you don't see a list of your city on this name list, please let us know and we'll be happy to start a chapter in your city. So I'll hand over the session now to Mr. Ajay Bhandari, who is President-elect of ILA Ludhiana and who is Director of Venture Code Legal. If you have any questions at any point, you may put them in the chat box and we would also request you to unmute, please. Yeah. So Ajay sir, over to you. For all the questions, please put in the chat box and you may also raise your hand to ask them. Thank you so much. Ajay sir?
Yes, you are audible. Yes, thank you very much, Madhura, for your kind introduction. Thank you. Welcome, everyone. Good morning. In today's session, we have our expert speaker, Mr. Jaswant Rawat. Advocate Jaswant Rawat is advocate on record in the Supreme Court of India, and he's a standing counsel for the state of Uttarakhand in the Supreme Court. He has been the standing counsel for the central government and Delhi government in Delhi courts. He's experienced over 30 years as a practicing advocate and is also a qualified mediator in Delhi court nominated by the Delhi High Court. He's a first generation lawyer in Delhi and expertise in various disciplines of law. So shall we start? So kind of you, Advocate Jaswant Rawat, being with us as an expert speaker. Shall we start the topic, Advocate Rawat? Please unmute, Mr. Rawat.
Yes, sorry. Yes, we can go on.
Right. So today's topic is very interesting one, Prevention of Money Laundering Act. Advocate Rawat, we all have heard about laundering. It's a very common term. But how this act is named as money laundering and how the lawmaker has defined it, please tell us.
Yeah, this act is very unique in the sense that under an international treaty, this act was enacted. The laundering is a word where we say that in laundering, the dirty clothes are washed and then it is the dirts are removed. So what happened in this act is that the dirty money means the money which is by way of a criminal activity. That is a dirty, and by putting in the system, this dirty money is converted into the legitimate money. So that is called a dirty money in the sense that this money is not a legal money. It is not earned by a legal means, and it is unaccounted money. It is money generated by criminal illegal activities. Therefore, it is called untainted money. And this untainted money, when put in the system, then it try to become a legitimate money. That's why this laundry word is used. It is a very unconventional word used. It is generally not used in the legal terminology, but because worldwide, it is in the foreign country, it is being used a laundry. So in our legislature, in their wisdom, has also used this laundry words.
Okay. And how the lawmaker has defined it, and what were the proceeds of crime as per the section 3 in this section?
They see that this act in the sense that they have said that whosoever knowingly and unknowingly derive any properties, means if you earn any properties directly, indirectly, in whatever means, by way of a criminal activity, if there is and the criminal activity, and then you try to project or claim it to be a legitimate money. So the point here is that if you earn money by of a criminal activity which is defined in the act, there is the schedule offenses are there. If you commit any offense and then you earn the money and then you try to project that money as a legitimate money, then it become a money laundering act as an offense. Therefore, the point is that in our this enactment, there are the schedules. Schedule A, there are the schedule which is called schedule offense. In schedule offense, वहां पर part है, part A, part B, part C.
Right.
Part A, part B, part C में various acts लिखे हुए हैं. तो अब अगर उन acts के part में अगर कोई भी activity, criminal activity में कोई भी FIR हो जाती है, तो the ED, Enforcement Directorate, will get a right to investigate the matter and then file a complaint before a special court and then start a trial in the matter. Simultaneously, the other proceeding also like attachment, investigation, other things. This is the way.
Okay. And what about there is a mentioning of a reporting entities and their obligations? So what are these reporting entity and their obligations?
The point is that this act is this is the topic which we have mentioned. It is compliance, precautions, and awareness. This act is in the sense the Money Laundering Act is a punitive and preventive act, and also an international obligation. So it has a 3-part. First part is the punitive, then it is a preventive, then it is an international obligation. Punitive, this reporting entity, because the Money Laundering Act is such an organized crime. It has done in such a fashion that is very difficult to detect it. Not only detect it, but also very difficult to get an evidence. So that evidence can be get only through a system. In our system, there is a financial institution, there is a banking institution, and there are other activities. So the law has defined it in the act, which is defined as the reporting entity. They have said that if you are a financial entity, if you are a banking sectors, if you are in the intermediaries, or if you are in any other business, then you are covered as a reporting entity. As a reporting entity, you have a certain obligations. That obligation, you have to fulfill it. And in breach of that obligations, you may be held for that, fine may be imposed upon you. And what are that obligations? That is very important. That obligation, so far the reporting entity is concerned, that the RBI has laid down certain guidelines to the banking sector. SEBI has laid down certain guidelines to our other sectors, financial sectors. So under that guidelines, one important factor is that you know your customer. First of all, that whenever you have a client, you must know your customers. And the second important point is that you must have a due diligence of your client. So these are two important aspects as a reporting entity who has to fulfill this, that you know your customer and then you have to due diligence. Apart from that, you have to report certain suspicious transactions also. You have to maintain the record also for a certain period of a time. And if the enforcement director asks for certain document, certain information, you are bound to supply. So there is an obligation on the part of the reporting entity to furnish informations to the enforcement directorate regarding the suspicious transactions, regarding the know-how of their customers, and this and for that, if they fail to do it, they can liable for a fine.
So when you said that the investigating agencies are free to get the information from the reporting entity, and the reporting entity are obliged to provide those information. So won't it be a breach of privacy?
The reporting entity will not liable for that because they get a protection here in the act. They get because this reporting entity has an obligation under the act to furnish that information. If they fail to furnish that information, then they can liable for that. So if there is a confidential information, they have to share with the ED.
Okay.
So
right.
I as a customer cannot claim as a privacy that it is my privacy. You cannot share with the ED or the authorities enforcement agency because it is my private document, confidential document. But this is the saving clause in the act that the reporting entity is bound to furnish the document to the enforcement directorate.
Okay. Let's say that the investigation agency finds some suspicious entities through the reporting entity. What's next? Then about say under the section 5, the attachment and all these procedure. What are the provisions?
The point is that the enforcement first, whenever you see that we as a government has a lot. So many agencies are working together. They have a lot of data. They have a lot of informations. When information that ED get information from certain from various sources, then they issue a so-called notice out to the entity, to the whether it is a any corporate or whether it is a reporting entity. They give a so-called notice on the so-called notice. They have the person against whom the so-called notice was issued. They have to give information to the enforcement directorate. And on the basis of the information directed, on the basis of the information furnished by the entity, if the ED thinks is that there is some criminal activity and some property has been derived from that transactions, then the ED has a right to provisionally attach the property, and they can attach the property provided that they have the officer. There is some officer who has been authorized by the ED to give a reason in writing that why they are provisionally attaching the property. The ED has a right to provisionally attach the property, and thereafter this provisional attachment is valid for 30 days. After the 30 days, the ED has to approach to the adjudicating authority for confirmations, and the adjudicating authority, that this is for 180 days, 30 days or 180 days. In 180 days, this provisional attachment has to be confirmed by the adjudicating authority. Adjudicating authority has to give a notice to the party whose property has been attached, and on the basis of the material furnished by the agreed persons, the adjudicating authority may release the property attachment or may confirm the attachment. And this attachment will continue till the trial goes on. Once it has been decided by the special court that the person is convicted for an offense, the property will be confiscated. Otherwise, the property will be released. And one important point is that under the Act, although I have seen the Act, there is a mention that the person whose property is attached, he has वो उसको property, suppose मेरी property है, मेरी property attach हो गई है, तो मेरे को एक्ट के अंदर ये लिखा है कि भाई मैं उस property को enjoy कर सकता हूँ.
Okay.
ठीक है. But 2013 में there is a rules, सेंट्रल गवर्नमेंट ने रूल्स फ्रेम कर दिए हैं कि अब ईडी को ये पावर है कि वो मुझे खाली करा सकता है.
Okay.
There is a rule. Although that rule is a contrary to the act, but there is 213 rule आ गया है कि जहां पर पावर दे दी गई है इन्फोर्समेंट डायरेक्टरेट्स को कि अगर कोई प्रोविजनल अटैचमेंट किया गया है तो वो जो जिसकी प्रॉपर्टी है उसको वो खाली करा कर पोजीशन ले सकता है. वेदर not only movable, immovable properties also, immovable property को भी अपने कब्जे में ले सकता है. So now it is very serious aspects, very serious consequences of that act.
Okay. So now I request the participants up to this stage, if anyone wants to ask any question, they can please raise or they can share their question in the chat box. Any participant want to ask the question? Please raise their hand, and we will unmute so that they can ask the question. Is there any? Edwin, is there any? No. Okay, let's move forward. Okay, Advocate Rawat. Now, next, you have told about the Section 8 also. What about vesting and vesting of property and confiscation of the property?
Vesting,
What is all about this?
confiscation of the, they see that this is vesting and confiscation is that, you see, so far this act is concerned. Act says that if there is a property which is attached, provisionally attached, then it has been confirmed by the adjudicating authority. That means it has vested with the ED. It has been vested with the ED. The person,
Hello, Aya.
owner of the person has no right here.
You have one. Please unmute Advocate Rawat. Please.
I'm sorry.
Yeah,
I'm
he
sorry.
can.
No. Now, what I was saying is that कि जिसकी प्रॉपर्टी को ईडी ने प्रोविजनली ये कंफर्म करने के बाद अटैच कर दिया है, दैट द प्रॉपर्टी के जो राइट्स है दैट वेस्टेड विद द ईडी. नाउ से फॉर एग्जांपल देयर इज अ प्रॉपर्टी, इमूवेबल प्रॉपर्टी, जिसको प्रोविजनली अटैच कर दिया है ईडी ने, लेकिन वहां पर टेनेंट्स हैं. वहां पर टेनेंट्स हैं जो अपने लैंडलॉर्ड को अपना किराया देते हैं. नाउ बाय वे ऑफ दिस अटैचमेंट जो लीज होल्ड राइट्स हैं, जो वहां के प्रॉपर्टीज का जो रेंट आना है वो ईडी के पास जाएगा. सो दिस राइट हैज बीन वेस्टेड विद द ईडी so long the trial has not been completed. But once a trial has been completed and either he has been convicted or acquitted, अगर उसको सजा हो गई है तो वो सारी की सारी प्रॉपर्टी कन्फिस्केटेड हो जाएगी सेंट्रल गवर्नमेंट में. दैट विल बी कन्फिस्केटेड. अगर उसको सजा नहीं हुई है तो उसको रिलीज हो जाएगी.
ओके.
पॉइंट इज दैट कि कन्फिस्केशन जो है वो दैट डिपेंड अपॉन द आउटकम ऑफ द क्रिमिनल ट्रायल. अगर क्रिमिनल ट्रायल के अंदर एक्यूज को सजा हो जाती है तो वो सारी की सारी प्रॉपर्टी जो है सेंट्रल गवर्नमेंट में वेस्ट हो जाएगी. सो दैट इज कॉल्ड कन्फिस्केशन. एंड द रियल ओनरशिप, जो रियल ओनर है, ही विल नॉट गेट एनीथिंग. ओनरशिप राइट विल बी ट्रांसफर्ड टू द सेंट्रल गवर्नमेंट.
Okay. Let's say an aggrieved person is convicted in the special court, right? So what remedies he will be having?
No, the point is that this is a very serious act. I tell you one thing, he has a right to file an appeal in the High Court. Special court, because the special court is session court. After session, appeal is raised in the High Court.
Are there any other tribunals?
No, that is for assess. That was for attachment.
Okay.
That for the attachment. So for
Please tell about those tribunals.
ये जो एक्ट है ना, इसके दो कॉन्सिक्वेंसेज है. एक है सिविल कॉन्सिक्वेंसेज, एक है क्रिमिनल कॉन्सिक्वेंसेज. सिविल कॉन्सिक्वेंसेज ये है कि अगर कोई मेरे क्राइम ऑफ प्रोसीड्स है, प्रोसीड्स ऑफ क्राइम है, प्रोसीड्स ऑफ क्राइम को बोलते हैं प्रॉपर्टी. अगर प्रॉपर्टीज में मूवेबल, इमूवेबल, टेंजिबल, अनटेंजिबल, व्हाटएवर इट मे बी, प्रॉपर्टी जो ड्राइव हुई है उस बाय दिस क्रिमिनल एक्टिविटी, उस प्रॉपर्टी को अटैचमेंट करना, ये अब एक सिविल consequences है. It's
So,
not
sorry to interrupt you, Advocate Rawat. We have a lot of advocates who are joined from south, so they may be having some problems. So I think it's better if you more concentrate on English.
Yes, I will. So what I want to say is that this act has two consequences. That is a civil consequences and the criminal consequences. When I say the civil consequences is that this proceed of crime is attached by the ED has a civil consequences in the sense that this proceed of a crime will, during the pendency of the case, will be vested with the government, ED, and after that it will go to the government. Now there is a legal remedy at every step. If it is a provisionally attached, then there is an adjudicating authority where it has to be confirmed within 180 days. If ED fails to confirm it 180 days, then it has to be released. Now, if suppose ED succeed to confirm it within 180 days, then you have a right to file an appeal before appellate tribunal against the attachment order.
Okay.
And
what about this cross-border implications as per the Section C of PMLA?
So that's why I'm saying the consequences is that here this what I will give one I will take just 1 minute. Here the attachment order is very serious of, because attachment order is the order which will either convict you or acquit you. This is the first stage when the investigation or inquiry begin. From that stage, you have to have some document in your possession to show your innocence, because here it is this act is that, unlike our criminal other act where it has onus is upon the prosecution to prove the case beyond reasonable doubts. So then the criminal jurisprudence, the onus lies with the prosecution to prove. Here the onus lies upon the accused person that he is innocent, and this proceed of a crime is by way of legitimate means, and it is counted money. So the first step, when the this ED provisionally attach the property, here you have to challenge it. Here you must have a document that no, this provisional attachment cannot be done due to this 1, 2, 3 reasons. What 1, 2, 3 reason is that this is called a precautions. I will tell you that what precaution you must have it. Okay. If you at that initial stage, if you have a precautions, you will be succeeded in later stage. But if you neglect, if you fails to, or if you neglect at that stage, you will bound to be in trouble, because section 24 of this act says the onus lies upon you to prove that you are innocent. Onus lies upon you that the proceed is by way of a legitimate means. Therefore, once a ED comes to you, give a so-called notice, want to attach the property, you must have every detail with you. And from that onward, because once a so-called notice will issue, definitely there will be a mention of the properties also. You have to collect the document also that look here, this is the property which is by legitimate means. This is the property which is counted which has been counted. I have complied with every rules and regulation. And not only that, because it is generally seen that when ED is attaching the property of not only the main person, but his family member, his relatives, other people. So what happens is that those who have a genuine property, those who are innocent, their property is also attached. Yes. So at that stage, when the so-called notice is issued by the ED, you have to be very, very specific and clear that this property is by way of a legitimate means, and this property is a counted property, and this is not outcome of any criminal activity. From onward, you will go step by step up to that last stage. And now, because there is a judgment also has come that if you succeed in adjudicating process that this property is a legitimate legitimate means, maybe the criminal trial will not go. The FIR will be quashed by the Supreme Court, by the High Court. So that's why I say the adjudicating proceeding is very important in the sense that if you succeed to convince the adjudicating authority that my property is by way of a legitimate means, and the adjudicating authority release your property, you will win at least 50% of your battle. 50% of battle, because then you can say to the criminal court or to the higher court that there is no offense made out against me, and this offense for money laundering has to go. Okay. So the release of the property is the most important point. That is the very important. That is very important. Not only release. There is a judgment of a Radhesham Kejriwal versus State of Bengal 2011 judgment is that where the Supreme Court has laid down the law, and it has been again confirmed by this latest judgment of SB Reddy versus Union Enforcement Director, latest judgment in the March, where the Supreme Court has said that the criminal proceedings and the adjudicating proceeding both can go simultaneously. You cannot say that first the adjudicating proceeding will go on and only then criminal proceedings. They can go simultaneously, and they are both independent to each other. But the Supreme Court has said that in case you succeeded in adjudicating proceedings, And Supreme Court has also put a causes that in case in adjudicating proceedings, the adjudicating authority confirm the provisional order, that will not go against the person. That will not go against the person if it is confirmed. But if it is not confirmed, but if it is in favor, it is not confirmed, it is in favor, then the nature of the proceedings will definitely, depending upon the nature of the proceeding, the criminal proceeding has to go. Like if suppose the adjudicating proceedings on technical grounds fails, on technical grounds, this adjudicating authority release the word, then he will not get a benefit. But on the merit, and you succeed to convince the adjudicating authority that my property is innocent, I am innocent, it is a legitimate property, and then by that on that basis, the adjudicating authority release your property, the criminal proceeding has to go, and the Supreme Court and the High Court has quashed these proceedings.
Quite serious implications under PMLA.
Yes, very simply. So the adjudicating proceedings are very, very important. If in the adjudicating proceedings, you have everything before the adjudicating authorities, because criminal trial is based upon the evidence which is gathered by the enforcement directed, and on the basis of that, the adjudicating authority pass an attachment order. The evidence are the same. So and in case the principle lies there, in case the adjudicating authority in a civil proceeding is not convinced, is not satisfied with the attachment order, in criminal trial, the standard is very high there, because you have to beyond reasonable doubt.
Right.
So when you cannot, on the basis of probabilities, convince the authority.
On a serious note of this very serious implications about the PMLA, can you tell us about what are the vexatious search?
Yeah, vexatious means sometimes it is a warning to the ED officers. It is overzealous officers that no, we have a power and we will. So in case there is vexatious search attachment, the ED officers can also be held liable for. And there is I think the punishment of a 6 month or a 2 month or something like that. It is in the, so vexatious means without any reasons, without any reason, without any materials. If some attachment is made out, some case is made out, so on the basis of vexatious search or vexatious proceedings, the ED can be held up.
Okay, we are having one question from Pratima Pathak. So please, admin, unmute Pratima Pathak so that she can ask the question directly from the expert speaker. Pratima Pathak, please unmute, admin.
Good morning, sir. So I had a question that can we have an example of a real case where we can actually differentiate between adjudicating authority, how the proceedings are going on, and how the criminal proceeding, vice versa, and any kind of difference in between?
Yes, yes. So, yes, there is a case. You see that there was a case when on the basis of unaccounted money, there a raid was conducted by the this income tax authority, and they found some unaccounted money in the residential or commercial premises of such person, and that on the basis of unaccounted money, the ED and the CBI has initiated their independent proceedings, and in fact the ED has also provisionally attached the property and cash of that person. Later on, when the matter goes on, then it has been found, the income tax authorities, that there is every compliances of the income tax. There was no evasion. All the money has been counted. And then CBI has investigated the matter, and CBI has also found it that, yes, there was no violation of the law. And the CBI has filed a closure report. Here the ED says, independent of the CBI closure report or income tax assessment orders, we as an enforcement agency under the PMLA will continue with the prosecution. The Supreme Court said, no, you can't do, because even the adjudicating proceeding, the adjudicating authority did not confirm the provisional attachment. Adjudicating authority was also convinced that the money which was recovered was from the legitimate sources. But the ED was insisting it no prosecution will continue because all these are independent proceedings. Supreme Court says no, it can't be. So this is the judgment. This is the latest judgment, Reddy judgment, which is a live example. This part.
For dear participants, it's a important opportunity. We have a very senior advocate from Supreme Court with us, advocate on record, Advocate J.S. Rawat. So it's a good opportunity for you to ask question and know about this very important matter. And we have one question from Advocate Amandeep Samra. So Mr. Samra, please unmute Mr. Samra. Mr. Samra, you can directly ask the question to Advocate Rawat. Advocate Rawat, Mr. Samra, Advocate Samra is the president of ILA Ludhiana chapter. Yes, Advocate Samra.
Rawat sir, we want to ask a question that how many
it's about the punishment, I think.
Hello.
Okay.
Yes, yes, I'm hearing you. हाँ, मुझे सुनाई दे रहा है.
समरा जी बताइए आप.
मुझे सुनाई दे.
पूछिए. Advocate Rawat, his question is
how much punishment could be given in this case, sir?
How
much
punishment?
Punishment.
I am talking about.
Yes, he's asking about the punishment.
Punishment under Female Act.
Yes.
3 to 7 years. There is a mention that 3 to 7 years and fine. If you have been convicted under the NDPS Act, then it is 10 years.
Okay.
And the point is that one another point which is to be where we have to discuss is that this is a non-bailable offenses. You may be able to get bail for scheduled offenses like IPC, like CBI matters, other matters, but you will not be able to get a bail so far PMLA is concerned. And there is no anticipatory bail provision also.
Okay.
Like Prevention of Corruption Act, IPC, you can go to the session court and आप वहां से anticipatory bail request करके court grant कर सकती है. But अगर PMLA में केस रजिस्टर हो गया है और PLA में जो है आप जाना चाहते हैं कि मुझे एंटीसिपेटरी बेल मिल जाए, नो प्रोविजन. रेगुलर बेल मिल जाए तो उस रेगुलर बेल में सेक्शन 45 में जो है ना ट्विन कंडीशन लगाई हुई है कि अगर हम एज एन एक्यूज कोर्ट में अगर बेल लेने जाते हैं तो द कोर्ट हैज टू सेटिस्फाई ऑन 2 पॉइंट. फर्स्ट, दैट द प्रोसिक्यूशन मस्ट हैव एन अपॉर्चुनिटी टू अपोज द बेल. फर्स्ट, that means that in the absence of the public prosecutor, the magistrate, the court cannot hear my application at all. So the notice must go to the public prosecution to oppose my bail application. Number one. Number two, I, as an accused, has to satisfy to the court concerned that I am not guilty. I am not a guilty. I have not committed an offense, and I will not commit an offense in future also.
Okay.
So this is such a stringent conditions that I have not committed an offense and I will not commit an offense and I am an innocent. And when I will satisfy these things to the court, then I am entitled to get a bail.
No provision of anticipatory bail.
There is no provision of anticipatory bail because there are conditions. First, the notice must go to the public prosecution to oppose my bail.
Right. Advocate Rawat, are there any monetary limits under PMLA?
Monetary
limits.
Yes, 30 lakhs. You see, if there is offense, petty offense, but there are 30 lakhs and above.
Okay. Well, elaborate it more, please. What is that more about the monetary 30 lakhs or more? What is all about?
Value,
immovable, movable values, total value.
You see that it is a value of the proceeds. Value of the proceeds of crime. If it is a more than 30 lakh and under the act, if it is a more than 30 lakh under the act, then it can be that act can be attracted. But now again is that if suppose the value is depending upon who has committed the offense is less than 1 crore rupee. You see, there is an exception clause. I say that the 45, section 45 says about the bail section. If suppose there is a woman, there is a person who has committed an offense less than 1 crore of rupee, value of the 1 crore of rupee, then he has a right to get a bail also.
Okay, what about the punishments under the vexatious search? Once again, I will ask you like to ask.
I think is that vexatious is the 6 months and the fine.
Okay. Right. Again, request, we have another question from Pratima Patek. Please unmute Pratima Patek. Edwin, please unmute her so that she can ask the question directly from the expert advocate.
Yes, she can unmute herself.
Okay.
So what about the politically motivated cases and any comment by the Apex Court on this matter, like especially in case of PMLA, because we see allegations that this is a politically motivated cases right now going on. So
Yes, see that you see that there is a judgment reserve in the Supreme Court, that is Vijay Mohan versus ED something, where all these issues are there. They say that this act has come into 2002. There is some transaction which is before 2002 also. So there is this act is a political. Yes, in certain sections the people are very agreed by the political reasons. But you said so far, if whether is a political or non-political, if an offense has been committed, it has to be investigated and it has to be tried. You cannot look into the political angle only. But yes, there is a use and misuse of the act. We cannot say simply because this act has been used for a certain political parties or political leaders, therefore it is a, maybe you can say that it is a misuse of the process, but they have a power to do all these things. Therefore, there are court, therefore there are high court, and therefore the Supreme Court also, and therefore in certain cases the High Court and the Supreme Court has granted the relief that where the power has been misused by the ED.
Dear participants, I think it's a very good opportunity and this topic is really very important, and feel free to ask the questions. We are having a very expert speaker, Advocate Jaswant Rawat with us. He's an advocate on record in the Supreme Court, very vast experience of 30 years. Please feel free to ask the questions, right? It's a good opportunity. Advocate Rawat, what about the punishment under the false information, section 63?
Well, see, that is false information, IPC, that 228, the act is said 228 and 195, IPC, the law, the prosecutions can be launched giving of false informations. So under 228 and 1, I don't know the exact punishment in the 195 or 228, but that is the power given under this act, that everybody is bound to give a correct information to the directive. And now one important point, which so far this act is concerned, there is a section 50. Section 50 says that any statement made before the ED is admissible in the court.
Oh.
So what happened is that when in the criminal matters, when accused make a statement or whatever statement is made before an enforcement registry, they are not admissible in the law. But in here, if you make a statement, that statement can be read against you as an evidence in the trial. Therefore, the ED officials has much more power than the police officers. They have in fact dual powers. They have a power of police officer as well as a judicial power also, because the statement which is generally recorded before a magistrate under 164 of the CRPC is admissible. So that power is now given to the ED official also, that if any statement is made before the ED officials, that can be read against the person, the maker of the statement. As an evidence.
We have one participant, Mr. Vijay Lashkare. He wants to ask a question. Yes. Please carry on, Mr. Vijay Lashkare. Please unmute. Yes. Admin. Yes.
You need to unmute yourself, Mr. Lashkare. Yeah.
Yes.
Rawat sir, very good afternoon to you.
Yeah, very good afternoon.
मैं ये जानना चाहता था कि ये ज्वेलरी इंडस्ट्री में PMLA किस तरह से इम्प्लीमेंट होता है
किसमें?
ज्वेलरी इंडस्ट्री
ज्वेलरी में तो है ये, बिकॉज ज्वेलरी, ये देखो ज्वेलरी को बोले, देखो देयर आर so many parts. You go jewelry, you go precious metals, even that precious metal, real estate matters, export. We are a huge
Specifically for jewelry, I want to know the detail.
ये देखिए ज्वेलरी में ये है कि as per this business, you have to maintain the records.
Yes.
Now, if you fail to record the record, what records are that? That is very important.
Right.
Now, so far this act is concerned, it has not mentioned anything about that record which you have to maintain. Now, we can take some guidelines from the act. Take an example of reporting entity. From the point of reporting entity, वहां पर ये लिखा है कि आपको ये करना है. क्या करना है कि नंबर 1 आपको जो है ना KYC, नो योर कस्टमर जाना है, तो और आपको उसका ड्यू डिलिजेंस करना है.
Okay.
और उसके बारे में सारी इंफॉर्मेशन रखनी है. और अगर कोई सस्पिशियस ट्रांजैक्शन लगती है कि भाई आप ज्वेलरी इंडस्ट्रीज में कोई आपके पास परचेज करने आता है, माना से फॉर एग्जांपल मैं आपकी दुकान में आता हूं और मुझे बोलता है कि मुझे 10 किलो सोना चाहिए और मेरे ये आप मुझसे 10 करोड़ रुपए ले जाओ,
बराबर है,
तो इट बिकम अ सस्पिशियस.
राइट.
ये आपकी ड्यूटी बनती है ईडी को बताना.
ओके.
आप कि भाई ऐसा आदमी आया था जिसने मुझसे सोना लेना चाह रहा था और ये पैसा वो मुझे कैश में देना चाह रहा था. मैंने बोला भैया कि मैं कैश में नहीं लेना चाह रहा. तो ये सारी की सारी प्रिकॉशंस जो है आपको डिफेंड करती है, आपके केस को स्ट्रॉन्ग करती है. इसका रिवर्स आप लेके चलिए. मैं आपकी दुकान में आके कहता हूँ कि भाई साहब मेरे पास तो 10 करोड़ रुपए पड़ा हुआ, मुझे 10 किलो सोना दे दो. आप कहते हैं भाई साहब 10 करोड़ रखो और ले जाओ ना. अब ये 10 करोड़ का जो आपके पास कैश आया है, it now become unaccounted money. Maybe that कि जो मैंने 10 करोड़ रुपए दिया था, मैंने कहीं पर ड्रग्स बेचे होंगे.
राइट.
और वो ड्रग्स से जो मुझे 10 करोड़ मिलके आया था, मैंने आपसे लेके सोना लेके मैंने ज्वेलरी मिलके अपनी वाइफ को, अपनी बच्चों को, अपने रिश्तेदारों को, अपने सबको मैंने उसको बांट दिया. और वो उसको सब मैंने लेजिटिमेट शो कर दिया. जो उसका सोर्स ऑफ रियल था वो इलीगल था, क्योंकि वो ड्रग्स से आया हुआ था. ड्रग्स के पैसे को लेके मैंने आपके पास सोना लिया, सोना से आपके पास 10 करोड़ रुपए आ गया और उस सोने को मैंने आगे अपने लेजिटिमेट मींस में बेच दिया. तो ये जो 10 करोड़ रुपए के लिए आपके पास लग जाएगा, आपके पास प्रिवेंशन ऑफ मनी लॉन्ड्रिंग. ये इसकी कॉन्सिक्वेंस है.
तो इसके बारे में सब लोगों को अवेयर करना चाहिए.
नहीं, अवेयर इसीलिए तो ये वेबिनार हम लोगों ने कराया कि इंडस्ट्रीज में.
मुझे बहुत अच्छा लगा, आप लोगों ने बहुत डीपली नॉलेज शेयर कर रहे हैं और ये सभी इंडस्ट्रीज के लिए बहुत ही महत्वपूर्ण है. आई एम रियली अप्रिशिएट.
मिस्टर विजय लश्करे, प्लीज इंट्रोड्यूस. आप कहां से हैं?
आई एम फ्रॉम महाराष्ट्र. आई एम कोऑर्डिनेटर ऑफ IBJ, इंडिया बुलियन ज्वेलर्स एसोसिएशन.
ओके. IBJ, Indian, that is IBJ called, right? Yes. Mr. Surinder Mehta is a secretary.
Yes.
A good friend of mine. Yes. Good.
Yes, I know that.
Okay. Are you satisfied with the answer, Mr. Vijay?
Yes. Thank you, sir.
Okay.
Both of you.
Thank you. Advocate Rawat, we have another question from Pratima. Please, Pratima, carry on.
So what about the appeal provisions and review applications, and what are the grounds on which we can appeal in this case? If
against which order? Appeal against which order?
Actually, I not read the act. I was just talking about the general
anyhow, need not to worry. You see that there is a appeal. There is you see that when an order is passed, when you say the review and appeal, there is no power of a review as such under the PML Act. There is appeal provision is there. There are two kind of appeal. Appeal against the adjudicating attachment proceedings. ठीक है ना? अगर आपके अटैचमेंट को कंफर्म कर दिया है एडजुडिकेटिंग अथॉरिटी, आपके पास अपील का राइट बन जाता है एपीलेट अथॉरिटी के पास जाकर, ट्राइब्यूनल के पास, अपीलेट ट्राइब्यूनल के पास. अपीलेट ट्राइब्यूनल के ऑर्डर के खिलाफ आपको अपील का राइट बन जाता है हाई कोर्ट में. सो दिस इज वन थिंग. सिमिलरली अगर आपको स्पेशल कोर्ट में मनी लॉन्ड्रिंग एक्ट के अंदर आपको सजा हो गई है, तो आपके पास आप उसके अपील का प्रोविजन आपके पास हाई कोर्ट के पास है. तो ये एक आ जाता है अपील का प्रोविजन. रहा आपके रिव्यू का पार्ट है, तो रिव्यू का जो एक आपको पता होगा, जो क्रिमिनल ज्यूरिस्प्रूडेंस में रिव्यू की पावर नहीं दी गई. इवन दैट की सीआरपीसी में भी रिव्यू की पावर नहीं। तो एक जो रिव्यूअर जो क्रिमिनल कोर्ट है, चाहे वो मजिस्ट्रेट कोर्ट हो, चाहे वो सेशन कोर्ट या स्पेशल कोर्ट हो, उनको सीआरपीसी में कहीं पर भी रिव्यू की पावर नहीं है। उनके पास रिवीजन की पावर जरूर दी गई है। सेशन कोर्ट को रिवीजन की पावर है, हाई कोर्ट को रिवीजन की पावर है, बट दैट इज अ डिफरेंट। So I think is that now this point is clear to you.
Advocate Rawat, are there any mandatory compliances for the investigation agencies?
Yes, there is a mandatory and enforcement directors.
Mandated by the investigation authority.
Yes, there
Like?
yes, there is you. So far this act is concerned, mandatory power provision ये है कि आप
mandatory compliances. I am talking about mandatory compliances.
What compliances means? Yes.
जैसे NDPS में होती है।
नहीं, वो ऐसा कुछ नहीं है। ऐसा इसमें सिर्फ ऐसा कोई compliances नहीं है। But there is certain mandatory provision. अगर वो enforcement agency follow नहीं करती है तो उसका benefit आप ले सकते हो।
Okay. What about the continuation of proceedings on the death or insolvency of the party?
उसका सिंपल ये है कि सपोज मैं हूं, मेरे खिलाफ अगर अटैचमेंट ऑर्डर पास कर दिया है, मेरी प्रॉपर्टी के खिलाफ अगर अटैचमेंट ऑर्डर पास कर दिया है और वो ऑर्डर की प्रोसीडिंग्स एडजुडिकेटिंग अथॉरिटीज में या हाई कोर्ट में या अपील ट्रिब्यूनल में कंटिन्यू है, और ड्यूरिंग प्रोसीडिंग्स में अगर किसी की मेरी डेथ हो जाती है तो उसके बाद जो हमारे लीगल ईयर्स है वो उसके अंदर स्टेप ऑन करके वो कंटिन्यू चलेगी। कहने का मतलब ये है कि अगर किसी की डेथ हो जाती है या इंसॉल्वेंट होती है तो वो अबेटमेंट नहीं होगी, प्रोसीडिंग खत्म नहीं होगी, उसके लीगल ईयर्स जो हैं वो उस प्रोसीडिंग्स को आगे चला सकते हैं। लॉजिकल कंक्लूजन।
Okay. We have with us, I think, my friend Dr. Vyasa Rao is a fintech expert with us. He's from a fintech industry, and Advocate Rawat, one word is being also used in this PMLA, encumbrances. Tell us about this, please.
Encumbrances means when suppose a property is attached by the ED, so there must be some encumbrances like that. Some loan has been secured against the property, certain grantee has been given the property. So when the property is confiscated by the central government, then it will be free from all these liabilities. So it will be free from all, there will be no liability against the property to the central government. Right. So that is free from encumbrances. That is meaning.
On acquittal, can a aggrieved person go for a compensation for the harassment and losses?
Civil liability, under the law of fraud, he can go, definitely. False prosecution.
Okay.
Under civil law of fraud.
Okay. We are having one question from Dr. Vyasa Rao. Dr. Rao, please go ahead. Please unmute yourself. Dr. Rao, please unmute.
Sorry.
Admin.
Yeah, thanks, Sajay, for inviting for this particular nice webinar.
Welcome, Rao. Welcome.
Yeah, as being in earlier from the jewelry industries, like most of purchases of diamonds and gold used to happen in cash. And this Angades always used to carry huge money, and most of the time I have seen they have a brush with the authorities, right? There is some kind of an unwritten law between the income tax and the Angadias during 1975, if I'm right. Okay, what kind of protection they have been given under the PMLA?
Okay.
The point is not clear to me. What he is saying, point is not clear to me.
Sir, Angadias are the people who carry Angadias. Okay, they are the people who carry huge cashes.
Yes.
And diamonds from between example is from Surat and Mumbai.
Yes.
Okay, most of the time, if you look at that, either income tax people or police people, they raid them, catch them. Even last couple of years back, even 200-300 crores worth of cash was caught.
Yes.
But there is an unwritten, what do you call, a kind of an agreement between the Angadias and the income tax.
Yes.
It was something like, I think like 1975, in the year 1975.
Yes.
Okay, so every time they go, unaccused. You have any light on the particular kind of agreements?
No, there's no agreement. What agreement?
No, it was there. It was there.
No,
I
no,
mean,
that is not.
Well,
If
one
it
of
is
my-
if it is that, it will be wide and issue. Now, how can they do it?
because I've not heard any kind of what do you call
No,
the
it can't
conviction
be.
till now.
Can't be. Any agreement against the law is not enforceable.
Because even today, if you look at the purchase of diamond and gold, it happens 100% on cash.
Yes, it happened, but that's why that is the reason that you see that this act has been come into, because certain criminal activity, because you said that maybe that this money to come through hawala, through terrorism activities, the cash is flowing to this your diamond industries through various. So that's why this act is there, to prevent all this activity. And particularly that this you see that the precious metals industries has is come under the act.
Yeah, advocate, but still the process is same. It has not improvised anything.
No, I don't know what is the process is that, but the law has changed.
Cash and carry. Totally cash and carry.
Now the process is changed. The law has changed. 2002. This act has come, now in force.
Right, sir. Okay.
So I say that please be aware about it. You must take a compliance and the precautions. Our topic is that for precautions. What precaution you must take it? Otherwise, person may be in difficulty.
Right. Okay.
Okay, we have another question from Advocate Amandeep Samra. Please, Advocate Samra, please unmute yourself and ask the question. Unmute, Mr. Samra. Yes, please carry on.
हाँ जी सर, मिस्टर रावत
जी,
इसमें जब ऑफिशियल्स रेड करते हैं तो हाँ उनको रेस्टोरेंट वगैरह लेने पड़ते हैं, जब वो ऐसे ही जाके रेड कर सकते हैं?
क्या लेने पड़ते हैं?
वारंट?
नहीं, कोई वारंट की जरूरत नहीं।
ओके,
कोई वारंट की जरूरत नहीं है। देखिए उनके पास सेक्शन लिखा है, सेक्शन 16 के अंदर उनके पास है सर्वे की पावर, कि वो जाके प्रॉपर्टी का सर्वे कर सकते हैं कि वहां पर क्या क्या है। सेक्शन 16 के अंदर, सेक्शन 17 के अंदर सर्च की पावर है कि वो घर के अंदर घुस के वो सर्च भी कर सकते हैं। सेक्शन 18 के अंदर उनके पास पर्सनल सर्च की पावर है कि वो आपको पर्सनल सर्च भी कर सकते हैं। सेक्शन 19 के अंदर उनके पास अरेस्ट की पावर भी है। ये सब कुछ वो सेक्शन 6 के अंदर, 5 के अंदर वो प्रॉपर्टी को अटैच भी कर सकते हैं। ये सब पावर उनके अंदर है। उनको करना क्या है? उनको सिर्फ ये करना है ईडी को कि एक राइटिंग में एक ऑर्डर निकालना है कि आई एम सेटिस्फाइड, आई हैव अ रीजन टू बिलीव, आई हैव टू रीजन टू बिलीव दैट सर्टेन मटेरियल इज देयर। अदरवाइज ये एक्ट जो है दैट इज अ नॉन कॉग्निजेबल, इट इज अ नॉन कॉग्निजेबल एंड बेलेबल ऑफेंस है। नॉन कॉग्निजेबल एंड बेलेबल ऑफेंस है कि ईडी को एक कंप्लेंट फाइल करनी पड़ती है मजिस्ट्रेट के सामने, और मजिस्ट्रेट के सामने कंप्लेंट फाइल करने के बाद तभी वो प्रोसिक्यूशन आगे चल सकता है। बट इसका मतलब ये नहीं है कि पहले केस फाइल होगा, पहले एफआईआर होगी और फिर जाके वो सर्च होगा और फिर जाके अरेस्ट होगा। नहीं, वो इससे पहले भी कर सकते हैं।
Right. Advocate Dawat, now. Okay, carry on, Mr. Samra. Please carry on.
रात के समय भी कर सकते हैं, सूरज छिपने के बाद?
वो तो ऐसा देखिए, वहां पर ऐसा कोई प्रोविजन तो बैन है नहीं है एक्ट के अंदर कि आप वो किसी 10 से 12 बजे कर सकते हैं या 12 से 6 कर सकते हैं। ऐसे सीआरपीसी इस पर एप्लीकेबल उन्होंने कह दिया कि पूरी की पूरी नहीं होती। वो अपने आप को पुलिस ऑफिसर मानते नहीं है कि हम पुलिस ऑफिसर है, तो उनके पास इतनी पावर है कि वो जब मर्जी आया आपको बोले कि जी कि हम ये ईडी के ऑफिसर है, आपको बस उनको ये दिखाना है और आपको जो है ये पूछना है कि भाई आप कौन है। अगर वो अपनी अथॉरिटी बता देते हैं तो यू हैव टू कोऑपरेट।
Advocate Rawat, we are having a very interesting question from Pratima Pathak is coming up. Pratima, please go ahead.
So does this reason to believe have any proper rational grounds, or it is without any grounds?
Repeat your question, please.
So does this reason to believe that they are filing a complaint and they have reason to believe and therefore they will be like going for search or seizure? So does this have to have a proper ground at it, or it can be without any rational ground? And does this have to be a reasoned decision or without reason?
No. It is not reason, but what the court says that they must have a material, tangible material. I can see ED can pass an order that I have a reason to believe this thing 1, 2, 3, and maybe a very good, but that reason must be based on some material, tangible material. So not only the reason to believe is that, but the reason to believe must be supported by a tangible material. And here it is a lie. Here, because most of the time, when the ED they don't have any material at all. They just pass an order. So the court has
reason to believe has to be rational.
Not only definitely it has to be rational, but basis on the certain material.
Yes. Pratima, what do you think?
If suppose there is no material at all, tangible material, that even that key, that is something there.
Right.
So if there is
Actually,
something
it's
there,
important. Otherwise, the whole thing will become very draconian altogether.
yes, that is a draconian law. You see that's why I'm saying is that when the adjudicating proceedings, you will challenge this attachment order, provisional attachment before a adjudicating authority, you have to look into all these aspects. You have to disclose all these aspects. You have to ask that, let them to place the material, what that material. And that is the reason that the adjudicating authority does not confirm the provisional. So there are materials.
We are having another question coming up from Advocate Jagdev Singh. He's the Vice President in Ludhiana, Advocate. Please, Mr. Jagdev Singh, carry on your question. Unmute yourself, please. Advocate Jagdev Singh. Unmute. अपने आप को unmute करें, please. Advocate Jagdev Singh. I think we are lost him. Okay, we are having another question from Advocate Rai. Please ask your question, Advocate Rai. Unmute.
Yes, sir. Hi to all. I have a question
Hello.
regarding can an individual person make a complaint for the activity of any act which he knows or feels connected with Money Laundering Act?
He cannot. He cannot, because the enforcement, the power is given to the enforcement authority. He has to approach.
Please, I think you ask your question again, Mr. Advocate Rai, please. I think
Yes,
something else.
Can an individual person make a complaint for the activity of any act which he knows or feels connected with Money Laundering Act?
Complaint to whom?
Regarding to
complaint करे?
The council as ED or any department.
That's why, tell me, I will tell you one thing is that here the enforcement agency is the ED. One. Here,
yes.
Second thing is that this is non-cognizable offense.
Okay.
Third, that even if you have a certain case made out, you can go to the magistrate and say that let the ED be directed to investigate the matter. Only the magistrate can say so.
Okay.
Only magistrate, because this is a non-cognizable offense. It is not a cognizable offense like if suppose a crime is committed and you go to the police station, that some cognizable offense has been committed and you register an FIR under section 154 CRPC. It is not like that. Here, here is that even that in CRPC, if there is a non-cognizable offense, the police will not register an FIR. You have to go to the magistrate. So here also, the offense is non-cognizable. You can go to the special court and can ask to the special court, direct the enforcement agency to investigate the matter, and maybe that by investigating authority, if the special court directed, can pass it. But the again point is that the proceeding under ED, the proceeding under this act by the ED is subjected to. This is subjected to the commission of offense, जो कहाँ पर है schedule offenses है. अगर schedule offenses नहीं है, तो case नहीं बनेगा.
Okay,
Some
can
is
I request
fine.
to Madhura, can we go ahead as long as the questions are coming up? And Advocate Rawat has just to shed light on certain judgments. Can we continue a few minutes more, Madhura?
Yes. We do have some 10 minutes more. No problem.
Okay. Advocate Rawat, now please shed lights on the certain important judgments under PML.
Important judgment, I had just said that this is a one important judgment. That is Radhe Shah versus Kejriwal versus of Enforcement Directorate. This is very important. And then JB Reddy versus Union of India. These are the very important judgments where you have a guidelines in the sense that I said that the adjudicating proceedings and the criminal proceedings are two different things. So if there the Supreme Court has laid down the law that if you successfully challenge the adjudicating proceedings and able to prove it that you are innocent and there is no illegitimate money, then this act will not be applicable and then you will get a relief. And if you fail to it, then the prosecution will continue and you have to prove it. So this is the very important judgment. Then there are another judgment now in Nikitesh Shah versus judgment. There are these two twin conditions was set aside, but by virtue of Financial Act 2018, again these two conditions was added in section 45 of PML Act, wherein at the time of considering the bail, the special court has to give a notice to the prosecution, and then the applicant has to prove is that he is innocent and he has not committed a crime. So this is the important. There are other judgment, and the most important judgment I say that Vijay Mohan versus Union of India is pending before the Supreme Court. We are so many gray areas. So many gray area. Gray area in the sense whether the CRPC will be applicable, all provision of the CRPC will be applicable, whether ED officials are police officers or not. What would be? So these are the very important things. We know that. I know that in coming 1 or 2 months, most of the things very clear at the Supreme Court.
Participants, we are just near to the end of this session, and if any participant want to ask any question, please go ahead. Please feel free. It's a good opportunity for you all. Please carry on. Anyone want to ask the question? Please raise hands. We were having Advocate Jagdev Singh. Is he here? Admit?
No, I think he has left the session.
Okay, Advocate Rawat, your ending note about this webinar, please go to. Advocate Rawat.
Yes, I think that's a very.
This has been really very useful and knowledgeable session.
No, as you have said earlier that our endeavor will be that to enlighten the important aspects of this PMLA and other laws which are affecting our corporates, individuals, and where most of the things are not very clear. By way of this question answer series, I hope that we will able to share our knowledge and experience to the common people. Thank you.
Thank you very much. Thank you very much, Advocate Rawat, giving us such a valuable and such an important information on PMLA, and we will continue with you on many important topics on law and legal matters. And on behalf of each and every participants, we are very thankful to you, and we will continue in touch with you. Thanks a lot, and thank you to our Executive Director of Indian Lawyers Association, Madhura, and helping us, giving us such a good platform. On behalf of, and also very thankful to the President of Indian Lawyers Association, Ludhiana chapter, Advocate Amandeep Samra, and giving us such an opportunity. On behalf of a Venture Code Legal and on behalf of a Indian Lawyers Association Ludhiana chapter, once again I thank to you, Advocate Jaswant Rawat. It is a really and very knowledgeable and interesting session. Thanks a lot. Thank you very much.
Thanks a lot, everybody, to have a
yes, wonderful session. Very wonderful session. Thank you. So this comes to the end of the webinar, Madhura. Thanks a lot. Thank you very much.
Thank you, everyone. Thank you, sir.
Thank you.
Thanks.